SJC-11737, Commonwealth v. Olajuwon Jones-Pannell.
Mr. Mitchell, you'll have to say good afternoon, I'm sorry to say.
Good afternoon, and thank you for hearing me, and may it please the court. My name is John Mitchell, and I represent Olajuwon Jones-Pannell. He is charged out of the Boston Municipal Court with primarily possession of a firearm. There was a motion to suppress heard on this matter, and the motion to suppress was allowed. It was subsequently, this allowance of the motion to suppress was subsequently overturned by the appeals court, and I, on my client's behalf, filed a request for further appellate review, which brings us here today. And I would suggest to the court that the appeals court, in their ruling that two of the judge's findings were clearly erroneous, were incorrect, and that this court should overturn their decision and reinstitute the allowance of the motion to suppress.
So the two findings are whether it's a high crime area, right?
Yes, Your Honor.
And what was the other one?
Whether it was a high crime area, they also indicated that, I believe they're linked, they indicated that the judge indicated in his findings that because the incident happened sometime after midnight had very little effect, or had very
that's
little.
Right.
And I would suggest that they're linked, that primarily in looking at whether it was a high crime area, his findings should not be disturbed because it wasn't clearly erroneous. Officer Anhos, who testified for the Commonwealth, testified that very vaguely that there were 3 or 4 general gangs in the vicinity of this area of Norfolk Ave. He testified that there was a firearm recovered. He also testified that there was a shooting.
But wasn't that something was within 2 weeks?
Within a couple weeks, but importantly, only one of these incidences he was personally involved in. One serious incident which involved a shooting where an individual was shot in the neck, but that's the one incident. There was no testimony, there was no evidence provided regarding these other incidences, whether they in fact happened on or near Norfolk Ave, whether there were any arrests.
What did Judge Duggan find with respect to those prior incidents? Did he make any finding at all? Regarding the prior
incidents, I believe his overall, I don't think he dealt specifically with those incidences in his findings, but he does say that that it wasn't, I believe correctly, that Norfolk Avenue was not a high crime area or a hot spot, particularly in looking at the officer's testimony that he was only involved in one specific incident involving a firearm. I mean,
and we don't know how close it was to this place anyway.
And it's not, none of the incidences occurred on Norfolk Ave. They're in the vicinity, as Officer Anhos testified.
This is in Dorchester?
It is actually in Roxbury.
Okay.
It's in Roxbury. There was a discussion about that. The judge took great pains. As the court knows, there was throughout the testimony, it was described as Norfolk Street, which is in Mattapan, but it's actually Norfolk Avenue, which is in Roxbury. And importantly, the judge...
do we know that the judge had the right street in mind?
I do believe that the judge had the correct street because in the beginning of the transcript, he took great pains to, he was looking at it from a jurisdictional perspective, but he wanted to know whether the court had jurisdiction. So they took great pains to figure out whether it was Norfolk Ave as opposed to Norfolk Street.
Was he hearing this as a Roxbury case?
He was hearing it as a Roxbury case. I think that was his concern. It was a Roxbury case, but according to the transcript, the gun cases in Roxbury and South Boston are typically heard in the Boston Municipal Court, which is what happened here. And in this case, that was simply the evidence. There was no other testimony regarding any specific instances, and I would suggest that Commonwealth versus Jones is on point. Johnson, I apologize, is on point regarding this, in that case, there's officers who are well aware of this area. They have responded. They've made numerous arrests. It's known as a high crime area. Even the officer doesn't even describe it as a high crime area. He describes these instances, just sort of leaves it, and never actually says that he finds it to be a high crime area, particularly because as an officer in the anti-crime unit, he wasn't working his usual shift. He was working an overtime shift in a random area within his district.
So what do we do with the appeals court's criticism of his use of the statement, the following facts are the only ones found by the court based on credible testimony? The appeals court was unhappy with him for doing that.
I think, I would suggest to the court that they were just prefatory statements. They didn't really, they can't control an appellate court's review of the case if the court...
Well, they can if they make it, they put everything in terms of credibility. Yes, they can.
Well, I suggest that if his facts are erroneous, then this court can, and as well as the appeals court, can overlook them. And that's the standard. And nothing, even the Commonwealth concedes, there's nothing that he states is erroneous. They indicate that he, may not look at the case the way they would like him to, but none of the facts as they lay them out are erroneous. The facts, he credited Officer Anhos's education, experience, and just found that based on what Officer Anhos saw, Mr. Jones-Pannell manipulating something in the front of his pants in an area that Judge Duggan found not to be a high crime area was not enough to give the officer reasonable suspicion to pursue him or to stop him. And I would suggest that that's not clear, that his decision and the facts he found were not erroneous, and his conclusions of law were in line with the facts and current precedent. If you look at the transcript, particularly in looking at what he observed, I think a lot of the testimony that came in from as far as Officer Anhos and what he observed Mr. Jones-Pannell doing with his hands is also vague. He doesn't even indicate that he believes that it's a firearm until much later in their interaction. It doesn't come out on the transcript until, as the panel recalls, Officer Anhos and his partner pull up to Mr. Jones-Pannell. They're in an unmarked car. He's in uniform. Mr. Jones-Pannell is walking, and Officer Anhos believes that he sees him adjust something in the front of his pants. They then say, Officer Anhos then yells out, "Can I speak to you?" Mr. Jones-Pannell continues walking. He says it again, "May I speak?" Officer Anhos says again, "May I speak with you?" He continues walking. Finally, Officer Anhos says, "Wait a minute," jumps out and begins chasing Mr. Jones-Pannell. When asked about what he saw as far as the movements by Mr. Jones-Pannell, he's very vague. He says he seems to be adjusting something. He doesn't see the outline of a gun. He doesn't even say that it's a gun, that he believes it's a gun. He doesn't testify to anything regarding what he thinks Mr. Jones-Pannell actually has until later in the transcript. I'll point the panel to page 21 of the transcript, where he has chased Mr. Pannell. Officer Anhos has chased Mr. Pannell and caught up with him and is attempting to place him in cuffs. And Officer Anhos indicates that Mr. Jones-Pannell stiffens his arm, and he states, at this time, Officer Anhos states, "I believe at this time he had a firearm or some kind of weapon inside of his pants." And that's when he's further questioned about his experience and how, based on his experience, he believed that this was some type of firearm. And that's well after even the appeals court concedes he'd already been stopped, because as the appeals court, I believe, correctly found, he was stopped and seized when Officer Anhos said, "Wait a minute," pursuant to Barrows.
What was the testimony of Officer Anjos about the hands? The judge found that he saw his hands in his pants between his waist and his crotch. And then it was later walking faster, keeping his right hand inside his pants. Did he say it was in the pocket of his pants, or it was literally in his...
That's another thing that I think that's an interesting question, because in reviewing the cases, I think similar cases that Isaiah, hand was in the pocket, that question is left unanswered, whether it was in his pocket, whether it was, the only testimony that comes out is that his hand remains in there. And I would suggest to the court that in looking at the entire interaction, that clearly the officer was operating under a hunch. if Officer Anhos believed he had a gun, I would suggest he wouldn't ask him 3 times to, may I speak with you? The entire interaction is Officer Anhos has a hunch that he has something in his pants and he wants to find out what it is. If he believed he had a firearm, he would have stopped him immediately and asked for a pat frisk, but he didn't. He continued to ask him. He didn't realize or believe that he had a firearm until he caught up with him further down, and he had already taken him into custody primarily.
All right, thank you.
I believe, thank you.
Good afternoon. May it please the court. Kaylin Campbell on behalf of the Commonwealth. I'm going to start with the facts. And this is a case in which
The facts found by whom?
Exactly, Your Honor. The judge made 21 factual findings in this case.
And a specific credibility finding, so those are the facts.
Well, Your Honor, here's the credibility finding. The following facts are the only ones found by the court based on the credible testimony presented. My brother posits in his brief, and the appeals court agreed with him, that means that the judge largely credited Officer Anhos' testimony. And because that's under Isaiah I, the only way that you can supplement.
Well, I mean, you're saying that this prefatory statement by the judge was intended to show that everything he didn't say was implicitly credited by him?
I'm not sure if it's implicit.
It's certainly not explicitly credited by him.
It's not explicitly
The only
credited
things that's
by him.
explicitly credited by the judge are the specific findings that he made.
Correct.
And what the appeals court had to do, and to do what it did, was to say that everything else that's in the record he implicitly credited.
Correct.
Which I find a real stretch, I have to tell you.
And I think this shows the problem with this type of statement at the outset of facts. In Isaiah I, this court was clear that when a judge makes facts, they should be stated clearly, concisely, and unequivocally.
And didn't he do that?
He
The only things I believe.
He did, but it's unsure. As to the facts, yes. As to his credibility determination, I think it's more unclear. Did the judge mean he discredited every fact not found?
Suppose he'd said that.
If he did say that, then that is certainly within his power to do.
I thought it says,
say it
these
right
are the
now.
ones I find based on what I find credible. These are the ones I find based on credible testimony. That's what he said. These are the facts I find based on credible testimony.
Sure, and if that means he discredited any facts
Right.
not found. But the problem is that's open to interpretation as 3 panelists in the appeals court and the majority of
Maybe
the
they
appeals
did,
court.
but for the moment, let's just focus on what the judge found.
Sure,
And but what we know we found are the
Yes.
facts
Yes.
stated.
Yes.
So we know those.
And we can go, the Commonwealth's contention is that 5 of those facts, 4 of them are clearly
We know
erroneous.
something else, though. Did he suppress?
He did suppress, yes.
Okay, so we know he made findings,
Correct.
and that based on those findings, the judge concluded that it should be suppressed.
Yes, Your Honor.
And when you argue, but he didn't make other findings that were testified to by the officer that would have supported a different outcome, that isn't an implicit statement to, you're doing what Isaiah suggests you cannot do.
To the extent that I am, I apologize. That wasn't my intent because I didn't read the discrediting statement at the beginning as explicitly as Your Honor is. But the Commonwealth, like in Isaiah, does contest that some of these factual findings are clearly erroneous based on the
So tell us
testimony.
what those are.
Sure. I can list them out. They're finding number 4, finding number 8, finding number 13, number 14, and number 16.
4, 8, 13, sorry, go ahead, 4?
14 and 16.
I'm just saying these are clearly erroneous.
Yes. Yes. 8, 13, 14, and 16 have to do with the chronology of events, so I'll start there. Justice Gantz asked a question to my brother what the specific finding was about the hand in the pants movement, and that's finding number 8. And Judge Duggan found that Anhos saw Jones-Pannell's right hand in his pants between his waist and his crotch, but didn't see any other bulge in his pants. And on the whole, I would say that got that right, but that's not Officer Anhos' specific testimony.
Well, of course, I understand it's not his testimony, but that's the whole point. This is what she credits of his testimony.
Correct. But to the extent that it leads to the inference that the defendant's hand was in his pants before the officer saw him, I don't think that that's supported by what Officer Anhos testified to. Specifically on
So
page...
a judge did not have to draw the inference, or he had to draw an inference?
Well, I would say that the judge can't...
He cannot draw an affirmative inference that his hand was in there if he testified to something that didn't permit that inference.
Correct. And Officer Años testified, and this can be found on page 14, that he specifically saw the defendant sticking his right hand into his pants.
You mean while he was walking?
Yes. If you...
And how does that differ from 8?
Right.
I believe it differs in 8 insofar as 8 could lead to the affirmative inference that the defendant's hand was already in his pants, that it wasn't, the action scene was not the defendant sticking his hand in his pants. Slight distinction, but I think it's important to be specific as to what the officers...
Actually, it's worse for you if he stuck it in his pants, because then he wasn't necessarily holding the gun.
Not necessarily, Your Honor. This can be found in transcript 27. The officer testified that his partner drew his attention to the defendant based upon the action of the defendant sticking his hand in his pants and keeping it there for the prolonged period of time. So it was both the action of sticking his hand in his pants and keeping it there that was really what drew the officer's attention to the defendant.
Suppose he didn't credit that testimony.
But then he shouldn't, but I think her point is he shouldn't have made an affirmative finding that he had his hand in his pants when he was walking.
Correct.
Right, because he did have his hands. He just says that Años saw Jones-Pannell's right hand in his pants, between his waist and his crotch, but didn't see any other bulge in his pants. There's nothing in there about when he saw that.
It's not, but by ordering the paragraphs, it creates a implicit chronology of events, which isn't necessarily supported by the way that the officer testified. But as to 13, 14, and 16, those are the findings about the defendant's pace and when specifically Officer Años called out, wait a minute. So in 13, the judge said Jones-Pannell turned a corner onto Marshfield Street, and Años, getting out of the police vehicle in a loud voice, called to Jones-Pannell, wait a minute. The next finding, 14, he says, the judge finds Jones-Pannell started jogging up Marshfield Street. That chronology is not supported by Officer Años' specific testimony, which can be found on page 17 and 18, in which Officer Años testified that as the defendant neared the corner, he picked up his pace to the jog at the corner, and Años yelled out, wait a minute, when the defendant started to jog. Once Officer Años said, wait a minute, the defendant started running full sprint. He was asked to clarify that on page 18, and he testified, when I stepped out the door, he, referring to the defendant, was turning onto Marshfield. I yelled out, wait a minute. And later on, he says, as he went down Marshfield Street, his pace quickened to a full sprint. So to the extent that there's a finding that the jog didn't happen prior to wait a minute, that it happened after wait a minute, and that the defendant was jogging on Marshfield Street, that isn't supported by Officer Años' testimony.
But he had said that in paragraph 11, that he picked up his pace, walking faster.
Correct.
So this is the distinction between walking faster and jogging?
Well, I think the difference is in 14, then he finds that the jogging occurred after Officer Años said, wait a minute. And then in finding 16, he says, 15 says Años started to chase Jones-Pannell on foot. 16 says Jones-Pannell began running, which isn't borne out by the specific chronology that Officer Años testified to.
But did the officer testify to an order of chronology based upon the order of questions that were put to him by the prosecutor?
Well, yes.
But does that necessarily determine the actual order of events?
Well, I think the judge can say, I discredit that the defendant started jogging at this point, but he can't affirmatively then say where there's no evidence the time that he started jogging. Does that make sense?
Yes.
Okay. And insofar as there's that error, that's what's problematic on these facts. And insofar as the first factual finding serves to discredit any other fact, I don't know what the court does in its place. I think it's appropriate, I guess, to remand in light of the clearly erroneous facts, because he has explicitly discredited any fact not found, including the facts which would show the proper chronology of this stop taking place.
But what has been argued is that the defense, that the that the clearly erroneous findings by the appeals court go to high crime area and midnight.
Correct, correct. As to high crime area, I don't think it's the label that's as important as what the specific testimony was. Factual finding number 4 has to do with high crime area, and it's actually very specific as to what the judge credited Officer Agno's testimony was. The judge found, although the officers knew of some crimes that had been reported in the neighborhood, Norfolk Street between East Cottage Street and Burrell Street was not a high crime area or a so-called hotspot. Agnos was aware of a radio call reported for shots fired about 2 weeks before on August 6, 2011, and also the recovery of a gun shooting in 6 months before August 6, 2011. Agnos also knew that there was some undescribed gang activity in this area. That doesn't quite line up with the specific testimony. Transcript pages 12 and 13 talk about that testimony. Agnos testified 2 weeks prior, he had personally responded to a call for shots fired and found a man who had been shot in the neck.
Does he say where?
Yes, he does. I believe he said where. I can't, off the top of my head, remember where exactly it is.
Do you remember whether it was right in this area?
It was right in the area. It might have been East Cottage Street. It's definitely either on page 12 or 13 of the motion transcript. But then he testified on 13 that 3 or 4 months prior, there was a firearm recovered on Burrell Street and a shooting on Hamlet Street, which he was aware of when he made this stop. So insofar as...
Those don't make it a high crime area either.
They don't, Your Honor. I would say that it's important. If you look at cases like DePisa and Gomes, this court explained that the label itself is not important for the analysis. What's important is the incidents that have occurred and the proximity to the stop that is occurring. And I'd say that it colors the officer's perception of the events that he sees as they're unfolding. And no, it might not necessarily have the label of high crime area, but the motion judge, in not labeling it a high crime area, then didn't consider these recent incidents of firearm-related activity in his reasonable suspicion analysis. And I'd say that is an error where it definitely does color the officer when he sees a movement, which otherwise may be interpreted as innocent. It helps to explain the officer's reasonable concern for his safety and why he interpreted the events as they unfolded as they did.
Okay, thank you.
Thank you.
Court, all rise.